Greetings of the day. So today we will discuss amending procedures. That is topic number 2 of your Canadian Constitutional Law NCA syllabus. Starting with the amending procedures, we should know that in Canadian constitutional law, the amending procedures for the Constitution are codified primarily in Part 5 of the Constitution Act 1982. It contains formulas that are meant to address the nature and importance of the amendment, ensuring that the level of agreement required reflects the significance of the proposed change. So, Part 5 of the Constitution Act 1982 provides the following 5 different amending procedures, that is, General Amending Formula, also known as 7 by 50 rule, under Section 38. Second is unanimity procedure, did it under Section 41. Third one is bilateral procedure, did it under Section 43. Fourth one is federal parliament alone, did it under Section 44. And Section 45 talks about the provincial legislatures alone. So coming to the general amending formula, also known as 7 by 50 rule, under Section 38, the general amending formula, commonly referred to as the 7 by 50 rule, is also found in Section 38 of the Constitution Act 1982. It provides that the Constitution of Canada may be amended if there is no specific provision to the contrary by resolutions of the Senate and the House of Commons, and two-thirds of the provinces having at least 50% of the population of all the provinces. Here the consent of the 7 provinces representing at least 50% of the population means that a combination of provinces must support the amendment, and at least some of the more populous provinces must agree. The population threshold ensures that provinces with larger populations, such as Ontario and Quebec, have a significant role in the constitutional amendments but cannot unilaterally block the changes. Further, Section 38, Clause 3 talks about the opting out provision. Under Section 38, Clause 3, a province that does not consent to an amendment affecting provincial powers can opt out of the amendment. And Section 40 deals with the compensation to the provinces. It addresses the issue of compensation for the provinces that choose to opt out of amendments under the general amending procedure when the amendment transfers provincial powers to the federal government. So, if an amendment under the 7 by 50 rule affects areas of provincial jurisdiction and a province opts out, the federal government must compensate that province for the change. Now come to Section 39. Section 39 of the Constitution Act 1982 places a limitation on how frequently the general amending procedure under Section 38 can be invoked for the same amendment. It establishes a 3-year waiting period to prevent the repeated attempts to introduce the same constitutional amendment if it has already been rejected. So here, if a proposed constitutional amendment under Section 38 fails to pass, that is, it is not approved by both the required federal and provincial bodies, no new resolution on the same matter can be reintroduced for at least 3 years. Now we will talk about the specific amendments requiring the 7 by 50 rule. Here Section 42 identifies specific areas of the Constitution that by default require the 7 by 50 rule to be amended. Following matters in particular must be made by using the general amending formula. Number 1, the principle of proportional representation of the provinces in the House of Commons. Number 2, the powers of the Senate and the method of selecting the senators. Number 3, the number of senators representing a province and the residence qualifications of the senators. Fourth, the Supreme Court of Canada, except for its composition. Fifth, the extension of existing provinces into territories. And the last one is the establishment of new provinces. Now come to unanimity procedure under Section 41. This procedure is reserved for the most fundamental aspects of the Constitution, where changes would significantly alter the core of Canada's governance structure or its foundational institutions. The unanimity procedure requires that an amendment to be approved by the Senate and the House of Commons and all the provincial legislative assemblies. Section 41 identifies 5 specific areas that require unanimity for constitutional amendments: the office of the Queen, Governor General, and Lieutenant Governors. Second, the right of a province to a minimum number of members of the House of Commons. Third, the use of English or French language. Fourth, the composition of the Supreme Court of Canada. And fifth one is amendments to Part 5 of the Constitution Act 1982. Now comes Section 43 that deals with the bilateral procedure. Here, Section 43 of the Constitution Act 1982 outlines the bilateral amending procedure, which applies to the constitutional amendments that affect only one or more provinces, but not all provinces. This procedure requires the consent of the federal government and the affected provinces for amendments that are regional in scope and not applicable to the entire country. It applies to the amendments that are limited to the specific regions or provinces, particularly in areas such as changes to the boundaries of the province, language rights in a particular province, or amendments to the educational rights of the religious or linguistic minorities in a specific province. Then comes the federal parliament alone, that is dealt under Section 44. It outlines the federal parliament's exclusive power to unilaterally amend parts of the Constitution that relate only to the federal institutions, that is, in relation to the Senate, the House of Commons, and any other aspects of the federal government's institutions. Now comes Section 45 that deals with provincial legislatures alone. It grants provincial legislatures the power to unilaterally amend their own provincial constitutions. This provision allows provinces to make changes to the structure and operation of their own institutions without needing approval from the federal government or other provinces. Now let's discuss reference recession of Quebec 1998. It's a landmark decision by the Supreme Court of Canada that clarified the legal framework governing a province's potential secession from Canada. This case addressed the constitutional questions surrounding Quebec's desire to unilaterally secede and the broader implications for Canadian unity. In 1995, Quebec held a referendum on whether it should secede from Canada, which narrowly resulted in a vote against secession. In response, the federal government asked the Supreme Court to clarify whether Quebec had the right to unilaterally declare independence under Canadian constitutional law or international law. So here the court held that Quebec cannot unilaterally secede from Canada under the Constitution of Canada. The court emphasized that Canada is a federal state and constitutional changes that affect the federation, such as the secession of a province, must follow the constitutional amending procedures. So here section 38, that is general amending formula, or we can say 7 by 50 rule. Here the secession of a province would fundamentally alter the structure of the Canadian Federation. Therefore, the 7 by 50 rule, that is consent of parliament in the 7 provinces representing at least 50% of the population, would be required. So this provision is used for significant constitutional amendments that impact the entire country. And section 41, that is unanimity procedure, would also apply because secession would affect the several key elements of the constitution, including the office of the Queen, composition of the Supreme Court, or amendments to the amending formula itself. If we talk about Section 43 in this case, if the cessation involved specific constitutional provisions affecting only Quebec, Section 43 might also come into play, requiring the consent of Quebec and the federal government. These sections collectively demonstrate that cessation would not be a simple process and would require extensive negotiations between Quebec, the federal government, and the other provinces, each acting under the relevant amending procedures. Further, the court rejected the argument that Quebec could unilaterally secede under international law, particularly under the principle of self-determination. It found that self-determination under international law generally applies to peoples under colonial rule or oppressed groups, and the Quebec does not fit these criteria. So this is all for today's lecture. Now come to the practice exercise based on today's lecture. I have drafted two MCQ questions. You can pause the video, read the question and send the answers in the comment box. First question is, which of the following statements best describes the amending formula introduced in the Constitution Act 1982? I have given you four options. Select the correct one. Second question is, what does the 7/50 formula for constitutional amendment require? Here are four options. Select the correct one and send your answer in the comment box. So this is all for today's lecture. For the latest updates on study material, IREX and mock exercises of Canadian constitutional law, please subscribe our YouTube channel and follow us at Instagram, and the links are provided in the description box. Thanks for watching the video.